All right, welcome back. It is 1:02 Eastern. Hope everyone had a good lunch. A couple things, just a reminder that public comment for today's session will begin at 3:30 Eastern. Also, Steve Finley has joined us, is in for the Office of General Counsel, and we were going to pick up where we left off. We had several people with their hands raised. I have the order of which they raised their hands. I'll go ahead and do that, and then we'll take it from there. Okay. All right. When we last left off, we had Amanda. She had her hand up first. Amanda, you have the floor.
Thank you. Just because we didn't really close out, or I didn't feel like there was a closure to the previous conversation before we left for lunch on H1 related to the deadline language there. I'm just wondering if other negotiators who brought up the issues related to the concerns of the deadline and incorporating that language there, was Greg's or the Department of Education's intention behind that language as it relates to federal, deadlines? Hearing that, did that really subside any deep concerns or potential scenarios that could, be harmful to students, or did that hopefully, address your concerns? And if it didn't, is there something, or is there an example you can help me understand? Because I suggested this language to the Department of Education, so I'm just trying to understand specific examples or scenarios in which that language would be harmful. Like, is it related to potential passive acceptances of award letters and having a deadline there that you're concerned about? If anyone could just please help me understand the real issue here. And hopefully the Education Department's original explanation hopefully subdued any other types of scenarios that you were concerned about.
Okay. Greg, do you have anything on that?
I don't have anything beyond what I said earlier. We have we could in that in H1 before deadlines we would suggest instructions and applicable deadlines for accepting and declining, if that would help assuage people's concerns.
Okay, I appreciate that. Thank you, Greg. Also, we have Ashley Schofield in for Minority Serving Institutions. We'll go to Jamie, you're up next.
Okay. I raised my hand to speak to the issue of career services, about which I feel pretty strongly. The current language is overbroad, as a number of people have said, and I agree with Barmack that focusing in on number 3 would get at the abuses that might be troublesome. So I will propose that the language be along these lines, focusing on 3, provides career services that it has publicized to prospective and current students, or consistent with its claims to prospective and current students. I appreciate, Greg, your explanation that the department needs particularly egregious situations, but there's a danger that that won't be clear to people, because there's also language that says must demonstrate. As a former career services dean, I fear that this language, coupled with that must demonstrate requirement, could distort the field and worry institutions that they all have to make or be prepared for a showing that's based on numbers and non-existent ratios, when all the department's best thinking and accreditors' best thinking is moving in the direction of capacity, effectiveness, and results. Ed's been telling us to think about outcomes. If you have concerns about capacity, I think you have the tools, and that language just talking about claims that have been made for career services would cover the need, which is understandable and reasonable.
Okay, I'll take that.
If I have a second, I'll say that I think any deadlines or any applicable deadlines, there's a lot of voice for that. And on the section afterward about clinicals, we like the addition of other and think that's a good change.
Thank you.
Thank you, Jamie. Barmac, you were in queue before lunch, so you're up.
Yeah, I'll be very brief, and I've put this in the chat. I want to echo Jamie's and Brad's comments with regard to career services. We have all heard the modernist dictum, less is more. In my experience, less is usually less, but this is an area where less really is more. Adding fluffy, unenforceable, vague language to regs as an aspirational sort of indication of toughness actually discredits the regs, because regs ought to be actionable. Regs ought to be meaningful to the regulated entities, and the department has to realistically have the resources, the capacity, the experience, the qualifications to act on them. This is just, forgive me for my bluntness, but this is almost like word salad. I think the single most concerning area of abuse is where institutions promise lucrative careers that they don't deliver on. And I think if the department focused its resources on where the real problem is, we can come back to the more grandiose vision down the road. So I would really encourage the department to avoid the tendency to just create more voluminous, meaningless regs. Thank you.
Thank you.
Thank you, Barmac. Deb, you're up.
Thank you. I too also share the concerns about kind of ill-defined ratios for institutions not knowing what it means and not potentially being helpful for the department. I will add though, I actually that would take me to a place kind of maybe in a different direction than Jamie, who kind of talked about leaning into the career services the institution has publicized to its students. That one seems to me, certainly institutions should not be misrepresenting what services they are offering to students. That seems very clear. But what they advertise or publicize to students seems like it actually bears very little resemblance to the sufficiency of those services. If I'm an institution, I don't publicize the availability of services, but I still don't offer them. That doesn't actually mean that the services are sufficient. So I would probably take that one out too, and then try to get at the misrepresentation of career services in a different route.
Thank you.
Thank you. Brad, you're up.
Yeah, it may make sense to let Jessica finish out the point I here. So I was going to move to my next point, but if there's still good discussion, which I think I agree with what Barmac and Jamie have both just said, I'll put my hand down and come back once we're finished with H and I.
Okay, Brad, thanks. In that case, then Jessica, you have the floor.
Thanks. I just, in reflecting on these, I think that there are actually two different types of representations that a school might make that are relevant to career services. One is representations about the career services themselves, something like lifetime job placement services. And the second are representations about, in fact, the careers that one obtains that would be impossible to effectuate without some career services by the school. And I think maybe separating those could help clarify what exactly, because I think only the first one of those two categories is captured in number 3, but not the second. And perhaps it's captured elsewhere, and that's fine, but I do think those are both really important things that need to be considered.
Thank you, Jessica. Okay, I don't see any other hands. Greg? Oh, sorry. Brad, you had your hand up.
Yes, so I'll move down to my next set of points in K, if that's okay. Have we gotten to K, Greg? I can't remember where we stopped before lunch. I'm sorry.
I'm sorry, I'm on mute. Have we got to, no, we were at, we were with I and J. We had yet to move on to K.
Yeah, my recommendation, based on all the commentary and I, is that the department considers the proposed language that either Jamie or myself has made and come back to us. But we can finish out the rest of the issue paper first on that though.
Jamie, you had your hand up? And you're on mute.
I think that Debbie and Jessica's points are well taken, and that the combination of both claims about services, or maybe it's 3 claims about services, connections with employers, and results are also potential areas for misrepresentation. So maybe we could marry all of what Brad, Barmack, Debbie, Jessica, and I have been saying to do something that hinges it to the claim section, but recognizes the multiple ways that that could happen, either by making it broad or specifically calling them out. I'd be happy to work with you offline if that would be helpful in that drafting. I don't have language right now for the misrepresentation section.
Okay, thank you, Jamie. Okay, I don't see any other hands. Greg, want to continue?
Sure. I didn't. I wanted to make certain there were no other points about I before we move on to K. Correct, Brad? You didn't have any comments you wanted to make about that before we move on to K? I want to make sure we.
Not anything in addition. Thank you for asking.
Okay, sure. So in that case, then we're going to move on to K. Renee's got that up already. And here we are at again at K, disperses funds to students in a timely manner, consistent with the student's needs. The secretary, and then we go on to say the secretary does not consider the manner of disbursement to be consistent with the student's needs, if among other conditions, and we list those conditions below. To address negotiator concerns and clarify our meaning here, we have further streamlined the language in the section by breaking out the examples into individual items that you see below. We have removed the cross-reference to 668, 164. That seemed to create some confusion during our last negotiation session. So you can see we broke all those items out. The secretary is aware of multiple relevant student complaints to make it clear that we don't mean one complaint from a student. The institution has high rates of withdrawal attributable to delays in disbursements. The institution has delayed disbursements until after the withdrawal date requirements in 668.22B and C, or the institution has delayed disbursements with the effect of ensuring the institution passes the 90-10 ratio. And next we'll move on to M, and then we'll do comments on K and M both. So let's look at M here. This refers to the institution offers gainful employment programs that are subject to subpart Q, and at least half of its total Title IV revenue in the most recent award year is not from such programs that are failing under subpart Q, and at least half of its full-time equivalent Title IV receiving students are not enrolled in programs that are failing under subpart Q. And this is accounting for negotiators' concerns during session 2 about the technicalities of how this language will work. We sought here to clarify that the administrative capability requirement applies only to the calculation of what percentage of total students and revenue are affected. So hopefully this clarifies the calculation somewhat. So before we move on, I'll entertain any comments related to paragraphs K or M.
Thank you, Renee. Sharing. Okay, Brad, your hand, followed by Ann. So Brad, go ahead.
I'll start with K, and you know, I've slept since the second session, so I forgot the concerns, what the concerns were with the reference to 34 CFR 668.164. You know, I know that section governs student disbursements, and I thought it did seem relevant here to ensure institutions are complying with those requirements. So remind me or what the concerns were from the committee on why we took out the reference there and then added in the language here.
As I recall, back at session 2, there was just some confusion about the reference to 164 and some, because there is in 164 considerable amount of latitude in dispersing. If you look at the time frames for dispersing as strictly defined in 164, it essentially allows the institution to disperse at any time during the payment period. And that is the overarching requirement, but I think here we're more concerned with practices that the school's engaging in where it is dispersing not in accordance with student needs, or but with an eye towards delaying disbursements, or somehow manipulating when those disbursements occur for reasons other than to the benefit of the students. So we felt it'd be more clear if we just spelled those out here as opposed to the reference to 164. And of course, 164 stands as it is. There's and still provides the basic guidelines for dispersing aid.
But why would we want it written two different ways in two different spots, you know?
Well, this is not addressing, I mean, 164 simply addresses the mechanics of disbursement. This addresses dispersing to students in accordance with, consistent with student needs. And the two are not necessarily the same. You know, 164 provides the limits, but this addresses, and remember here, we're talking about administrative capability, assessing an institution's administrative capability, and as part of that, looking at the way in which the institution disperses and whether or not within the framework of what's provided, of what's allowed for in 164, the institution is dispersing aid in accordance with student needs. And that's why we've spelled those out here. For instance, you know, delaying until after the withdrawal date of students in 668.22, that I don't think it's a common practice now. It used to be that institutions that didn't want to do, they weren't necessarily trying to get out of returning funds, but just didn't want to be bothered with the calculation. So would wait until after the 60% point had elapsed before they would even disperse funds to students. So things along those lines, where clearly the practice has nothing to do with what is in the student's benefit, but what the school trying to avoid some administrative requirement or manipulate disbursements for some other reason, 90-10. So I think the two are really different things, right?
And then I've got a point on item 1 and 2 under K, to Romanet 1 here, where it says the secretary is aware of multiple relevant student complaints. This is a new ad coming into this session. And, you know, I of course understand that you want to consider complaints, but the word multiple, I'm not sure how many that means. And the other concern is just sometimes students don't understand the Title IV process. And so a complaint about the rules and institutions following to comply with Title IV should be considered. So is there department planning to verify if the complaints are significant before making any findings here? And how many does it consider to be multiple? Is that more than one?
Well, we don't have a number that we place on it. Certainly more than one. Well, I mean, it might be possible that one complaint is of such a serious nature, or it seems to be so to raise concern sufficient to have us look into it. But very seldom do we look at one. We will look at that complaint. We say we don't not look at the complaint, but we don't view one complaint as normally as indicative of a pattern of a difficulty at a school. And yes, we do look into those. We do look into those complaints, even where we get multiple complaints. It could be that the students are not understanding of just the rules for related to dispersing funds. But I can say that in most cases, in my experience with multiple complaints, when we've had, we've had institutions that are having difficulties with, financial difficulties where they don't have a lot of staff, or, you'll get 30, 40, sometimes more than that, students saying they haven't received their disbursements for a specific period of time, or say for the fall semester. And when we see something like that, we generally will look into it further, and that would be indicative of conditions where an institution was not dispersing in a timely manner. I don't think you can never really narrow it down to, would it be 3 complaints or 4 complaints? A lot would depend on the size of the institution. There is a certain amount of subjectivity involved that I don't think you can get out of here. But this does give the department a valuable tool to look at instances where schools' practices are prejudicial to students. And we've seen this before, where students can't pay their bills because an institution is not dispersing in a timely manner. And sometimes they've had difficulties with turnover or something along those lines. But all that notwithstanding, if some of these students don't get their aid, they're unable to pay their basic expenses. So we feel it's an important and necessary element for this and tool for the secretary to have. But to your point, Brad, I don't know that I can put a number on it. I mean, is it 3 or 4 or 5? Well, that would depend on the circumstance. We do evaluate. I was to say we do evaluate those claims and the validity of them. And there have been plenty of times where I've had to tell students that what they thought was a violation was simply a misunderstanding of rules.
Thank you, Greg. I did propose some language. I think if we just put a clarifier in there that basically is adding a few words to the back end of K Romanet 1 that says the secretary is aware of multiple relevant student complaints, and this is the insertion, and has verified the legitimacy of such complaints to consider. And then my last comment is on K Romanet 2, and if I run out of time, I can get back in line. But again, I've mentioned this in the first 2 weeks, that the department still has not defined what a high rate of withdrawals is, and even how it could prove they were attributable. The withdrawals were attributable to the delays in disbursements. I don't know how in the world the department, number one, if we don't know what the high rates are, we don't know whether or not we're administratively capable, but number 2, how you could then prove that those high rates were attributable to delays in disbursements. And so the department here, can you please help me define what high rates of withdrawals
30 seconds, Brad.
And how those delays would have been, or those withdrawals are attributable to those delays?
No, we've not given a number here as to what, again, what is a high rate of withdrawal. And there is some subjectivity here as well, but whether I've not, as far as a situation that would be where withdrawals are attributable to the high rate, to the high withdrawal rate. I'm sorry, where delays in disbursement are attributable to the high withdrawal rate. I'm not certain of exactly an example of how that would work. We have seen situations where a school was, in the instance I'm thinking of, just having difficulties financially and administratively, and just wasn't able to get their disbursements done. So yeah, I mean, if you saw students having to withdraw from that, I don't think you might not have an official withdrawal rate associated with that. because we'd rather be tied to that particular term or whatever. But I'll take that back and see if we have some more clarification on that. But I do understand your concerns there, Brad.
And I just struggle that the department can't tell us what that means in this session. How can we vote for language that the department does not know how it would apply to us? But thank you for the listening.
Thanks, Brad. Let's see, Ann, you're up.
Sure. I had a quick question, and I'm really probably looking for the department's thinking on this. So in both I-1 and in M, there's a reference specifically to only gainful employment programs. And certainly, you know, there are lots of programs within higher education where students come to college seeking a career. My first degree is in finance. So why is gainful employment specifically called out in those items?
Well, yeah, if we look at M, this has to do with the revenue. The whole concept of failing programs, failing of GE rate is only associated with gainful employment programs, as programs that prepare students for gainful employment and recognized occupation, which would be all programs of proprietary schools and non-degree programs, for the most part, at not-for-profit public and private institutions. So it has to do with the fact that that's a statutory category, gainful employment programs, and that with this, in M, we talk about at least half the Title IV revenue is from programs. At least half the Title IV revenue in the most recent year is not from programs that are failing. The only programs that would be subject to failing or passing are gainful employment programs. Which is not to say that, I mean, if your point being that in contemporary education, a lot of programs certainly that are not considered gainful employment programs are still preparing students for, in some cases, specific fields like engineering, finance, accounting, nursing. But they're not in most cases gainful employment programs under the statutory definition.
Okay. All right, thanks.
Any specific comments on K or M? Okay, Greg. Back to you.
Okay, we'll move on to, let's move on to O. And, this is, I'll wait for Renee to pull up the issue paper again. And there we go. All right. Has not been subject to a significant negative action by a state or federal agency or an accrediting agency, and has not lost eligibility to participate in another federal education assistance program due to administrative action against the institution. And here we have made a technical change to use subject to, which we believe is more common parlance for state and or federal actions. And that's everything for O. And then if we move down to, let's see, P, I want to move down to Q, and that is not and does not have any principal or affiliate of the institution, as those terms are defined in 2 CFR parts 180 and 3485, or any individual who exercises substantial control as defined in 668 174 C3. And this is added language that closes the gap between the existing definition used for principal or affiliate and the current past performance regulations for an individual who exercises substantial control by incorporating both cross references. And continuing in, and that was in Q1. And if we'll move down to Q3, has been convicted of or pled nolo contendere or guilty to a crime involving the acquisition, use, or expenditure of federal, state, or local government funds, or has been administratively or judicially determined to have committed fraud or any other material violation of the law involving these funds. And here we have also added an additional provision supported by a negotiator related to crimes involving federal funds or findings of fraud. And in 4, a current or former principal or affiliate, as those terms are defined in 2 CFR parts 180 and 3485, or any individual who exercises or exercised substantial control as defined in 68174C3 of another institution whose misconduct or closure contributed to liabilities to the federal government in excess of 5% of its Title IV HEA funds. And here we have made several changes to this item to use an existing definition of a principal or affiliate of the institution to clarify that the individual in question may still be employed by the institution if the institution is still open, and to clarify that the individual has contributed to liabilities to the federal government. We've also capitalized federal government. And I'll stop there. That would be through Q, and take any comments.
Thank you, Renee. Thanks, Greg. Let's see. I see Jamie, your hand's up. You're first.
Okay. Mine is pretty simple. It's on O, and O says has not been subject to a significant negative action by a federal, state agency or an accrediting agency. There's just a question of time here. There's a danger that that could be misread to be any time in history. And this issue has come up in another location on something similar. And I suggest that perhaps there be a time horizon, or that you clarify in some way that if there was a negative action that was resolved and the institution is in full compliance or has been for whatever period of time the department wants. It's just a time saver, because I don't think you need it to be eternal.
No, the intent here is not for it to be forever.
Right.
Certainly not if the institution has resolved the problem or the whatever the factor was that led to that significant negative action taken. Did you have any proposed parameters around this or language?
I really was seeking the department's sense of, I mean, are you looking for is now in compliance, or would you like to see compliance for a certain period of time? I can try and work up language, but I really think it's important.
I think any significant action, certainly, I worry about a time limiter here, because any significant action taken by these entities that is yet to be resolved is a factor, I think. Regardless of putting some time frame around it. I wouldn't want to say 2 years, but it isn't resolved, and therefore,
yeah,
it would not be considered. So,
yeah, no, I
you're
understand
looking for
that,
something
Greg.
like to the extent to whatever it is that precipitated the action has not been resolved.
Maybe it's as
Something along
simple
those
as is not subject to a significant negative action. if what you mean is not now under that kind of order, I think the solution is simpler. There are
I'll
other
take that,
places.
I'll take that back. I don't know, whether or not we've, and there could be, and just in thinking this through, there could be situations where a school maybe has resolved these, but there are ongoing issues that they keep arising where they are subject to these significant negative actions. And I would ask the committee, does anybody have any thoughts about that, limiting it, if we were to limit it to those that are outstanding, or, what about the concerns of an institution who may have resolved some of these, but has ongoing issues with negative actions being taken against them? I just throw that open if anybody wants to comment on that.
Carolyn, is that specifically on that question?
Yeah,
go ahead.
I'm not sure that resolved necessarily would work here, because, for example, you could get a state or a federal agency could get a judgment against a school of finding misconduct, and that would be a resolved situation that I think the department might want to be able to consider. Like, in other words, that a court case could end and be resolved.
Yeah, and I think this does give us, the way it's written gives us that sufficient latitude for that. I mean, if the concern is that, I could say that we certainly wouldn't look at, an institution that had a negative action taken 10 years ago and significantly resolved and sufficiently resolve that. Will we say that school's administratively incapable, going forward, forever? No, no, we would not do that. But I'm just not sure how, and to your point, how we could put language in here that would give us the latitude that we need, not just limited to those that have not been resolved, but yet make it clear that we don't mean forever. I can just say that the department's intent is not that it be forever. I don't know. I don't want to say anything limiting the department to not being able to look at this merely because something has been resolved. I mean, resolution could be very important. We always want to see things resolved, but again, there could be an ongoing pattern of problems that, for whatever reason, the institution is able to resolve to the satisfaction of one of these entities, but still indicates the institution that we have a lot of concerns with that institution. So we'll look at that.
And I would just suggest that if there are other concerns, they should be at a level that they are covered by something else so that there is notice. So I think that is not subject to a significant negative action is one way to go. If you want to be able to continue to look at the basis for that, I understand. And I think some way of assuring that it's not, that the department would follow the negative action to its conclusion if there were resolution. But I'm not trying to add a lot of words.
No, I see what you're saying. You have
that's
concerns
fine.
about it being in perpetuity, that if somebody resolves, if an institution resolves something in 2022, that in 2035 the department would say, oh, but you had this.
You once had this problem.
You once had this problem, therefore you're not administratively capable. I can say we wouldn't do that, but if we're looking for something, more assurances in the language, I'm not 100% certain what that would be, but it's a good point.
Okay, thank you. Thank you, Jamie. Do you have anything else to add? Okay, thanks. Thanks for your patience. Brad, you're next.
And I think Jamie's proposed language is better than currently written. I do think some sort of resolution is important here. I like the word unresolved. I'm not a lawyer here, but I'm not sure how you could resolve something in the department still think is significant, but I've obviously never seen an instance of that. So, but I do think there's some language there that needs to be added. And potentially maybe something in P Romanet 1 could be utilized here, but I'd like to go to new in Romanet 2, Romanet or no, I apologize, just in, new in under misrepresentations and aggressive recruiting. Did you get there, Greg?
I see where you are.
Okay. As you know, the department's proposal here allows for to find an institution administratively not to be administratively capable if it engages in these misrepresentations and aggressive recruitment. And as I mentioned in the previous two sessions, you know, we still don't have a definition for aggressive recruitment, and we're still not including anything in front of misrepresentation, which I propose the word significant misrepresentation. But given we've had a lot of back and forth on that, I'm wondering now why we're including the word including twice here. Are there any instances that the department is referencing here where an institution is in compliant with subpart F and subpart R, but is somehow not compliant with this subsection N? Are there other types of misrepresentation and aggressive recruiting that violate this section but do not violate is the subparts F and subpart R?
Okay, so you're asking does not engage in representations of misrepresentations as defined in subpart F of this or of this part, or aggressive recruitment as defined in subpart R. So you're saying, is there, I'm not sure I understand your question, Brad. You're saying, is there some way that they could not be engaging in misrepresentation as defined in subpart F, but still be violating subpart R?
No, what I'm saying is we've added the word including here twice now from week 2 to week 3. And so I'm asking why we're doing that, and could you be in compliance with subpart R and subpart F under these two as described in those subparts, but not be in compliance with this in administrative capability? Like, is there a reason why we're adding the word including in two parts right here?
I see what you're saying. Does not engage in misrepresentations, including those defined in subpart F, or so you're saying, would it be possible for a school to be in compliance with the letter of subpart F and subpart R, but still be still run afoul of N in that it's because it's does not engage in misrepresentations, including those?
Yes.
Does this extend to misrepresentations beyond what is defined in subpart F and subpart R? Yeah, it does. It does give the department it does give the department latitude beyond what is defined in the subparts. Because as it's written, it does engage in misrepresentation, does not engage in misrepresentations, including those. I would imagine that most of those would be covered under subpart F or subpart R, but it does leave the possibility for the department to view something as a misrepresentation that is not strictly defined in those subparts as written.
To me, I would think being administrative capable is a level above those other subparts, and to me, I would think I'd be surprised that you could get past the definitions in subpart F and subpart R and not be administratively capable. So, well,
you wouldn't be. Well, if you were run afoul of those, you wouldn't be administratively capable. But this says does not engage in misrepresentations, including those. So those are definitely stated, but it would be possible for there to be a type of misrepresentation that is technically not included in subparts F or R. So I mean, there would be no way of not being compliant with or running afoul of misrepresentations in subpart F, for instance, and still being compliant with N.
Well, in addition to the comment on including, I don't want to forget my first comment that the fact that we're not saying a misrepresentation has to be significant to be administratively capable is extremely important, in my opinion. And again, we are defining aggressive recruitment that is yet to be defined, or referencing a definition that is yet to be defined in administrative capabilities. And I have a real problem with that as well. Thank you.
Thank you.
Thank you, Brad. Let's see, Barnack, you're up.
Yeah, my comment is on O, but I want to echo Brad's concern about the use of the word including because it expands the universe of potential tripwires here, and they're not articulated anywhere else except in the citation. So I would advocate deleting including so that subparts F and R basically articulate what the issues are. I don't agree. I'm not that worried about the fact that we don't have a regulatory definition of them. That is outside the scope. Whatever it is, that has gone through its own process, and we need to treat it as a black box, unfortunately. I just wanted to flag on O, and I've said this when the issue has arisen in financial responsibility triggers. Remember that I do not believe any other agency, well, some other consumer protection agencies might, but federal agencies, particularly the VA and the DoD, do not deal with the entire institution in their judgments. They deal with programs offered by institutions. So an institution could actually run afoul of VA rules and lose eligibility for 3 of its programs while retaining eligibility for 3 others. So you may want to consider, I realize this is maybe nitpicking, but you may want to consider changing the opening of subpart A by saying, up top you have institution, you could start O by saying, or any of its programs have not been subject. Because the judgment would typically, in the case of VA and DoD, be with regard to programs, not with regard to the institution as a whole. Thank you.
Thank you, Brian. We do consider that we have authority under this to that we do under this rule retain the ability to apply the finding if a sanction or action is applied to a program within an institution. So we have looked at this and conclude that consider rather that we do have such authority, but you don't think that this is strong enough language?
If I defer to your judgment, if you think you have the authority, then that's fine. Let's not complicate.
We do. We have
okay.
Checked with counsel, and we do believe that this does give us.
Okay, good enough for me.
Thank you, Barmack. Let's see, Ashley, you're next.
Yes, I just wanted to echo my support for what Jamie's comments were earlier related to discrimination. HBCUs in particular have experienced this with predators, particularly sex. And so just making sure that there is clarification regarding the language as it relates to including the words that Jamie mentioned earlier, excluding the words. And so just wanted to just echo Jamie's sentiments related to discrimination and the encounters that HBCUs and MSIs in particular have had with their predators.
Thank you.
Thank you, Ashley. Carolyn, you're next.
I just wanted to express support for the inclusion of the language in N that relates to misrepresentations, including the including language. The reason why I think that is actually helpful here is that there are relevant state laws on misrepresentation and aggressive recruiting that are or may be broader than what's going to be in the federal regs. We don't know what's going to be in the definition yet, but we have some idea based on the negotiated rulemaking. And it seems to me that language could be potentially the proposed or whatever came out of the rulemaking language is narrower than some state laws that might define aggressive recruiting potentially more broadly. So that's a situation where even under there could be relevant borrower defense claims that reference the violation of state law and misrepresentations, and that is a relevant consideration for administrative capability. So my suggestion would be that it would be meaningful to leave the language that is currently proposed about misrepresentations and aggressive recruiting for that purpose.
So, Carolyn, you're saying to retain the you would favor retaining the where we say including as defined in subpart F and R, but not absolutely limiting the department to what is defined in those subparts, correct?
That's right, because I think that there is a purpose for that, which would be to make sure that if there are broader state laws that are violated, those are captured as well here, because it seems like that would be relevant if a state law is violated too.
Right, thank you.
Jessica, you're next.
Thanks. I was going to make the same point as Carolyn, but perhaps in a less sophisticated way, which is just, I think that we would all agree that an administratively capable school does not engage in misrepresentations, period. And if that's true, then I think that including language is the correct language to be there, which is we can give examples of the types of misrepresentations that that school does not engage in, but the higher level principle stands. And then separately, I just wanted to make a quick note on O, which is, I'm not sure if this would assuage Jamie's concerns or anyone else, but this provision, as I read it, just says an administratively capable school has not been subject to negative action in these various ways. And I think that is different. Like what this isn't saying is a school is administratively incapable if these actions have happened. And I'm not sure if the daylight between those two things would maybe help your concerns, but I just want to point it out.
Thank you.
Okay, I don't see any other hands for O or Q. Greg, want to continue?
Sure. Let's move on to, just to make sure I get all my letters correct here. Our various. Since moving on to, we're moving on to V. I'll wait for Renee to pull that up. I think all of us are going to be seeing crossed out letters in our sleep, trying to determine which paragraph for this. Okay, so here we are in V, and this is no, we don't. Let's see if we have any changes here. I don't believe we have. No. We don't have any, there are no changes for V, I don't believe. So I'm going to move on. I thought there was a change in V, but no. And, oh yeah, we are staying in, yes, there is. I just was in the wrong place. So we are going to V, V2, that's where I want to be. I was just in V, I was in the wrong part of V. So this is a, and there it is. Thanks, Renee. I'm sorry for my confusion. So in V2, a high school diploma is not valid if it does not meet the requirements established by the appropriate state agency in which the state where the high school is located has been determined to be invalid by the department, the appropriate state agency in which the high school was located, or through a court proceeding, was obtained from an entity that requires little or no secondary instruction or coursework to obtain a high school diploma, including through a test that does not meet the requirements for a recognized equivalent to a high school diploma in 34 CFR 600.2, or was obtained from an entity that maintains a business relationship or is otherwise affiliated with the eligible institution at which the student is enrolled and is not accredited. So we are aware that some states do not regulate non-public high schools, and so there could be a concern that such diplomas are not recognized. So what we have done here is put in some suggested language that indicates that diplomas are invalidated if they do not meet the requirements that are established by the state. If the state does not have if the state has not established such requirements, including for non-public high schools, then we would generally not apply this requirement, absent other indications of fraud. So I'll stop there because that is the last section in admin capability we have to discuss, and I'll open the floor.
Thanks, Greg. Kelly, you're up.
Thanks. I put in the chat some additional proposed language as it relates to the concern from private high schools than the concerns that they have as it relates to not necessarily being regulated by states and all the different states having different rules for consideration. Because I think the original proposal that we had submitted was not accepted. So this is kind of a compromise between the two.
Joe, any further comments on that, on the nature of these changes?
Well, I think, I mean, I don't know if you can open the Word document, but in 1 Romanet 2, the recommendation would be to take out if the high school is regulated by the overseas state and area agency, and just say confirming with or receiving documentation from a state agency that the high school is registered or meets requirements established by that state agency. And then changes in to Romanet 1 and 2, where Romanet 1 would just say is not valid if was obtained from an entity that does not meet 1 Romanet 2, as opposed to the language that's there. And then the second one, Romanet 2 has been determined to be invalid by the department, and strike the appropriate state agency from that language.
Okay. Any comments on that?
You, Kelly. Let's see, Brad, you're up.
Thank you. I'm have a question on B1 Romanet 1. And it's, a question that has been raised several times throughout this rulemaking, and I don't believe it's been answered yet. So I'll try and ask it as directly as I can. So how can an institution verify a high school diploma by contacting the high school if the high school has closed? It's an important part of a problem if the department is yet to answer. And are we supposed to deny all such students admission from closed high schools no matter what? It's not clear to me how we go about getting one of the 3 items in Romanet 1, A, B, and C, if there's no one there to send it.
Yeah, I can address that. We remember here that we're only we're requiring the institution to develop adequate procedures to determine the validity of a high school diploma, and we don't believe that the occasional individual whose diploma cannot be verified will fall out of compliance with this requirement, because we certainly understand that may well be the case. So we're not going to say that where a school is closed in an instance where the school is unable to do that, that means you've run afoul of the regulation, as long as you have put into place adequate procedures to determine the validity of these diplomas. We do think it's critical to hold institutions to a higher bar for its regular procedures in the event that the school or department believes the diploma to be invalid, and require the institution to exhaust those procedures to the extent that is practicable in these cases. So obviously, there's always the possibility that a student's school is closed, and that you will not be able to obtain that information from that closed entity. But we still feel that the regulation as written is necessary to hold schools to the standard. But again, we want to reiterate that the inability to do that for the odd student whose school is closed is not a violation here. We expect that would happen.
Okay, well, I had proposed adding a Romanet 3 It basically said if the high school the student attended is no longer open, the institution must take other reasonable steps to verify the validity of the diploma, such as contacting the entity that may serve as a repository for the closed high school's critical records, if applicable, but the student is not barred from participating in Title IV HEA programs solely based on the high school is no longer open. So again, I think it's, to Greg, this actually says kind of what you just verbally replied with, and would be important to add for students to, or schools to know what to follow.
Thank you.
Thanks, Brad. Barmack, you were up.
Yeah, a couple of concerns, one of which has to do with the high likelihood that the kind of diploma mill you may be most concerned about could be an online high school that has methodically sought out the least rigorous place it be recognized and then reaches out and touches people across the country. So as a general practice, it may be better to index the state recognition process, not so much to the location of the high school, but to the location of the students when they enroll. Because it's really the satisfaction of the secondary educational requirements for the student where that student is that creates a meaningful high school diploma. So you may want to change that language where you refer to the location of the high school by indexing the location to where the student is. Now, if a student from Bethesda, Maryland goes to a private institution in the district, the student is located in the district for purpose of this language. So we're not talking about the state of residence, but where the student is receiving the instructions. We have kind of parallel language down the road that I'll send around for higher education distance programs. But in this case, I really think the area of greatest concern would be online high schools. So I think indexing the state recognition process to the location of the student would be pretty meaningful. And also, I am aware of a legal memo that our friends at NICU circulated, and I think Kelly is sort of partially attempting to encapsulate some of that memo's ideas into her language. I worry about that because, again, here we have just the recognition of a state as the metric, and I don't know that what the least rigorous state may approve is necessarily appropriate for a student somewhere else. So I have some reservations about that. I understand the concern that private high schools have, but we also have to concede that the likely area of fraud, unfortunately, will, it's not going to be in the publics. It's going to be within the private secondary system. It'll be an entity that purports to be a private nonprofit. So, I think this language we have is generally reasonable, but I'm happy to hear any counter arguments if anybody wants to offer them.
Thank you, Barmack. Anyone else have any comments or questions on V2? Yes, Jessica.
I just wonder if this again is a place where the word applicable might do some of the work that we're concerned about rather than the requirements, but applicable requirements, because I understand, maybe I'm misunderstanding Kelly, but I understand the largest concern is that in the absence of applicable requirements, what happens?
I'm sure, exactly where would that be, Jessica? Would you consider?
Sure, I was thinking of it in V2 Romanet 1.
V2 Romanet 1, where it does not meet the requirements established by the appropriate state agency in which the appropriate state agency where the state of the high school is located. Is that what you're talking to there?
Yeah.
Addressing rather. So you say it does not meet the applicable requirements?
It's just a suggestion. The concerns. It's just a language suggestion for concerns that weren't mine. So I'll let someone else speak to that. I don't know if that would address the concerns, but as I understand it, it might.
Then I go back to, again, we're looking at what we're trying to address here. These are situations where the institutional secretary has reason to believe the high school diploma is not valid. So we're not, we're not talking here about assessing the quality of high schools overall, or even the quality of those online. Or it's a matter of where there's reason to believe that the high school, where you have reason to believe that it wasn't valid, and it makes it I think puts the burden on institutions to look where they're aware that there's a diploma that seems spurious, or certainly where institutions are knowingly and willfully engaging in a practice of contracting with high school degree mills. We've seen a lot of that out there. This gives us what we need to go after that. If there are no other comments, we've had there have been a lot of suggestions here, and I am assuming some of these things are areas you want to see addressed before a consensus vote. So if it's please, facilitator, I would like to adjourn for approximately let's call it till 2:30, and have a discussion, internal discussion, and come back with our reaction to some of the language that's been proposed here, since this is our last, this is our, sort of our, not our absolute last shot at it, but we are going to take a consensus vote. So I'd like to have some discussions before we come back and do that, if everybody seems amenable to that.
Sure, but we have Kelly's hand up. You want to go to?
Oh, sure.
Kelly
And take everybody's comments first. Yes. I didn't mean to suggest we're cutting off. I'm not cutting off a discussion at all. I didn't see anybody else's hand up. My mistake.
Okay, I see. Okay, so I see two hands up. That first would be Kelly, and then let's see, Sam. Go ahead, Kelly. You're up.
Yeah, no, I just wanted to address what Jessica just said with the thought process of maybe adding the word applicable, because that may work. Because I think the concern is that, when we talk about not meeting the requirements established by the appropriate state agency, some of these privates are not required. There are no requirements from a state agency. So if, in fact, depending upon the state where they were in, if the said potentially, requirements, if applicable, established by the appropriate state, that might get there, because that way it kind of pulls out the ones that don't have those requirements.
Okay, that's noted. Thank you.
Thank you, Kelly. Sam. Sam, you're on mute.
Apologies, sorry about that. I just wanted to go back again to section H1 before you break, before the department breaks for discussion, and again say that on behalf of the Financial Aid Administrators Group, there's significant concern about the words "and deadlines" in H1, and support Kelly's proposal to just strike those, as they don't add value. They create a perception that deadlines are required. So students schools might manufacture deadlines that aren't necessary. And then that students, particularly low income and first generation students who already struggle to meet and understand deadlines, might miss those deadlines and lose access. It just creates more obstacles all the way around, and doesn't add value in the context here.
I'm trying, and I guess I'm just trying to understand this fully. So you're talking about going back to H1, but if the institute,
it's just the deadline reference, because
the deadline reference. So if
and deadlines, yeah, because I think it creates an incorrect perception that deadlines are required and need to be addressed, and then schools who might not need deadlines or have them currently might feel like they have to add them, and then students will miss them and not understand. It will delay dispersing of aid and processing of aid, and particularly because we find that the students who are historically late when we do have application deadlines in place are low income and first generation students.
Okay, I'll take that. I do want to clarify though that the department is not, this is not imposing any deadlines. If an institution policy was that they had no deadlines to disclose, then or to that's just in the disclosure requirement, but to provide in providing adequate counseling that they have, you know, that there are no deadlines. We're not, and I can see your point that maybe an institution could you know, take this to mean that there needs to be deadlines, but
right. I mean, all the more reason to take it out if you're not suggesting, you know. But
let me just ask this question. But to the extent that an institution does have deadlines, and we know some do, many do, should students not be made aware of those?
Absolutely, they should. We have deadlines typically apply to applications that need to be completed for FAFSA, other applications.
Right.
Labeling, but not deadlines for accepting, declining, or adjusting award amounts. Those are
okay. I see what you're saying.
And,
so the reference here to whether the deadlines as applicable to the acceptance or decline or adjusting.
I mean, applicable works, but I just don't think there's a reason to have it at all. It still creates unnecessary confusion. Even when I read it the first time at the end of last week, it made me think, oh my gosh, we don't have deadlines for accepting awards, and now what? It just.
Okay. All right. I'll take that back. Okay.
Thank you. Thank you. We have Kelly and then Marvin. So Kelly, you're up.
Yeah, and I just want to add on to what Sam just said and go back to the whole concept of that. If there are deadlines as it relates for accepting, declining, or adjusting, those are going to be in the instructions. So we don't need to say instructions and deadlines, because that will be in the instructions for accepting, declining, and adjusting award amounts.
Okay, thank you, Kelly. Marvin?
Yeah, kind of to both their points that, applicable deadlines should be part of any communication from financial aid, not just about accepting, declining, or adjusting awards. It's about completing verification. It's about applying for aid. It's about completing promissory notes. So I totally agree with Sam. It just adds more confusion and maybe sets up a scenario where a school says, nope, we didn't hear from you, and we're going to cancel all your aid. And I don't think that's what you intend. So I think deleting deadlines, and it's going to be in our instructions, fixes this issue.
Thank you.
Thank you, Marvin. Adam, you had your hand up?
Hi, so I was looking at number 2 on the validity of the high school diploma, and what I just want to confirm, I think the intent is that if there was a concern raised before about high schools that have closed, so I just wanted to confirm, I think, the department would consider the degree valid if the student, obviously the school was open at the time when the student got their degree, but has since closed. So if I could get confirmation that that's the intent here, that if a school has closed, the degree is still valid. But if so, maybe it could be phrased to make that clear, like saying that doesn't, meet the requirements established. If the degree was valid at the time the student completed their degree. So putting some sort of time descriptor in there so it's clear that if the school is now closed, the degree is still valid.
I mean, yeah, I mean, it's certainly the degree being, the school being closed would not in and of itself invalidate the degree. I don't know that we would want to say that if the school's closed, it necessarily will be out of compliance, that it necessarily is valid. So I think that is a something we have to consider. So you would want something that would say if the institution is confirmed to be closed, that it would automatically be a valid degree, or that the institution would have been considered to have exercised its adequate procedures to make that determination.
Just that the validity of the degree is based on the recognition of the school, at the time they obtain the degree. So I guess I'm not sure on the exact language to best achieve that, but just to make that clarification somewhere within 2.
Okay. Consider that.
Thank you, Adam. And it's a little after effect, but just wanted to announce for everyone that Adam was in for State Attorney General. Going back to the queue, we have Jessica.
Thanks. If I understand what Adam's saying correctly, it's that under 2, V2, Romanets 2, 3, and 4 are in past tense, but Romanet 1 is in present tense. And I think what Adam is saying, or what I understand, Adam, sorry, I don't mean to put words in your mouth, is that perhaps 2, Romanet 1 needs to be tied to the time period at which the student attended the school, so that it would be something like did not meet the applicable requirements established by the appropriate state agency at the time of attendance, or at the time, I don't know, it's outside my area of expertise, but that just makes sense to me from like a common sense perspective.
Adam. Oh, sorry.
Yeah,
I just want to say I saw where she was.
I was just going to say, sorry. Yeah, Jessica, I think that's correct. I think maybe within 2, Romanet 1 saying did not meet. So as opposed to does not might accomplish the concern or address the concern.
Thank you, Adam, for that clarification. Okay, I don't see any other hands. Before we pause a live feed, Greg, I know you were looking at about a 30-minute break, and it's about 2:19. Is that what you're still proposing?
Yeah, I think we need a little bit of time to review all of this. It's a lot. I want to make sure we give everything due consideration. Yeah, so I'll leave it to the facilitators to do the math.
Okay.
Yeah, it's 20
sure.
after.
It's
20 after. So.
2:50 by my count. So why don't we pause the live feed until 2:50, and then we can come back. Welcome back, everyone. We're back from our break. It is 2:52 Eastern. I'll go ahead and turn it back over to Greg.
Hello, everyone, and thank you for bearing with us during the last 20 minutes or so. Before we have a vote on consensus here, we're going to pull up some revised text and just take a look at some of the revisions we've made here to address the comments we've had. I'll explain where we are with these. The first place we'll start with is H1. And you can see here that we have made the, we've retained the nature of the aid and the applicable deadlines. We've added applicable deadlines for accepting, declining, and adjusting award amounts. Our reasoning here is first of all, this was largely language from advocates that are concerned about students having all the information that is necessary for them, and if there are applicable deadlines. And I want to reiterate that there may not be applicable deadlines. This does not in any way obligate the school to impose deadlines of any sort. This is an admin capability provision, so it's not in the operational language in 668, 164, for example, that's pertinent to disbursements, or 165 to notices and authorizations. So it is here as a measure of admin capability that and to the extent that if there are those deadlines and they are applicable, that they should be conveyed to students through the provision of adequate counseling. And want to make sure I hit everything. So the next place we're going to move to would be, I think, okay, if I'm not mistaken, I might have to rely upon Renee to steer me in the right direction here. Yes, this in K, let's see. Here we have a revision. This disperses funds to students in a timely manner, consistent with the student's needs. The secretary does not consider the manner of disbursements to be consistent with the student's needs if, among other conditions, the secretary is aware of multiple and verified relevant student complaints. So we have made an adjustment there to indicate that the complaints would have to be multiple in nature and have been verified. So that is a change there. And then if we go down to, I believe, N does not engage in, right? If I'm not mistaken, right? I just want to. We elected not to make any changes here in N. Just to review this, does not engage in misrepresentations, including as defined in subpart F, or aggressive recruitment, including as defined in subpart R. We did not want to limit the department to, although we believe that the majority of misrepresentations or aggressive recruiting would indeed be covered in subpart F or in subpart F or subpart R. Respectively, we didn't want to limit the department to that because there could be other areas of misrepresentation that perhaps would be relevant state law, and we want to retain our authority there. And with respect to misrepresentation itself, it is our belief that any misrepresentation is not a good thing. I mean, certainly there is more significant misrepresentations than others. However, unlike, I think you could easily make a case if we were talking about, for instance, I don't know, I'm trying to think of something that would be, R2T4 calculations. The institution did 200 of them correctly and one incorrectly. That's an error, and obviously thresholds apply there and should. With respect to misrepresentation, that is generally something done with an intent to deceive. So we determined not to make gradations there about what type of misrepresentation that would be. Moving on to the next one, where we made changes. I think we're at in V, if I'm not mistaken. Right, and this, just hold on a minute here, I want to make sure we didn't have any, I didn't miss anything else. I'm trying to go back and, oh, Renee, can we go back to O? I don't think I'm not sure we did O. I'm going to apologize to everybody. Yeah, thank you very much, Renee. I'm sorry I missed this one. This is another revision we have made here. Has not been subject to significant negative action by a state or federal agency or an accrediting agency where the basis of the action is repeated or unresolved and has not lost eligibility to participate in another federal education assistance program due to an administrative action against the institution. So here we have to address those concerns about where there may have been an action in the past that has now been resolved. We have added that it would be where the basis of that action is repeated or unresolved, so that if it's unresolved, obviously, but if it's a pattern of negative actions taken, where even if the institution is resolving those in some way, that we still have the ability to look at that if it is repeated. There could be situations, for example, where you know, an institution just agrees to pay a liability without any admission of wrongdoing or something, but where there could obviously be something there that we are concerned about. So we think this covers all those bases. Okay, Renee, then we can move on to, let's go back to V. And here you see a revision to high school diploma being valid. High school diploma is not valid if it does not meet the applicable requirements established by the appropriate state in which this agency in the state where the high school and the student is located. So we did make a revision there. And I don't think we have any, I think that is it. Correct. So with that, I will, those are the, you know, we went, I took it back. We did have a discussion amongst Ed staff, and those are the, where the department feels it has to be at this point. So I guess we could move for a vote on consensus, unless anybody has any final comments before we do that. I'll turn it back over to the facilitator.
Thank you, Greg. There are, let's see, there's one hand. I think it's Barmack. Two hands, Barmack and Jamie, before we take a consensus check. Go ahead, Carl. Go ahead, Barmack, you're up.
But Jamie was ahead of me.
Oh, so her hand went down. Okay, Jamie, go ahead. Take it away.
I'm not going to play jockeying. If we were in person, we would see the hands. First, Greg, I just want to be sure that you didn't skip over a change to little I and the career services issue. Is the department saying there's nothing you can see to improve that one? For example, even dropping the number and distribution of career services staff.
Yeah, and under career services, this was in, let me just go back to that. Yeah, provides adequate career service eligible students who receive program assistance in determining whether an institution provides adequate career services. The department considers, and then the following In this case, the department elected to make no changes to that. We feel that it's that we don't want to limit our ability to look at this to those services specifically expressed by the institution that are offered, because it limits us in addressing institutions that offer negligible or no such services.
And I think it's has been all along, we've said right from the beginning that it seems an inappropriate weighting of the department into a program quality issue. And I'm surprised that the department doesn't want to move in the direction it urges all the rest of us to move in, about thinking about outcomes and not inputs like the number and distribution of career staff. I understand you're trying to get at a problem that could be serious. And I think we, having sat through 3 weeks, understand what administrative capability means. But I fear that there will be behavior out there in which institutions think that they have to design career services to meet this and nose counting, as opposed to letting services be reviewed alongside all of the other student and academic services by the institution and their accreditor. So I respect the concern, but I think it is a serious one. And I'm surprised that you can't move in the direction of at least dropping item number 2. But I'll step back and listen to other comments before I decide how to vote.
Thank you.
Thank you, Jamie. Armac.
Yes, I wanted to go back to section V and the change you made to the location language. I really don't think you want to have, you don't want to limit it to only those cases where the high school and the student are located in the same place. Far from it. The concern is where the high school is in one place and the student somewhere else. So it really has to be pegged to the location of the student. This handles face-to-face, even when it's across state lines, because the student is located in the same state as the high school when the student goes there. But specifically with distance ed, you really want the laws of the state where the student is located to be satisfied that the high school is legitimate. So that conjunction has to go. I would suggest deleting high school and simply indexing the issue to the location of the student.
Could you pull that back up again, Renee? Okay, so we're looking at if high school is not valid, if it is not valid, if it does not meet the applicable requirements established by the appropriate state agency, rather, in the state where the high school
where the student is located,
where the high school, and so you would want in the state where the student is in the state.
Yeah, just for clarification, this is sort of jumping the gun, but between the two sessions, Carolyn and I were schooled by our friends at WICHE and WCET on the issue of pegging of requirements to students, and that language we will bring forward for you, but they really convinced me that the proper way of controlling for these things is to focus on the location of the student.
Just trying to play that out. So if in a traditional situation where a student was attending a traditional high school, brick and mortar, then the location of the student, you say, would necessarily be where the school is located, right? But
by definition, yes. When it's either within the same jurisdiction or the state, as in this area, somebody may be leaving Maryland to go to DC to high school. And then in that case, the location of the student is DC, even though their residence may be Maryland. But if a student is taking an online high school and the high school is in Wyoming, then the student's location then that Wyoming school has to satisfy Maryland requirements. And that's the right way, because the student is, we have a compulsory secondary education law in the state of Maryland, and high schools have to satisfy that. The student is not leaving the jurisdiction, as would be. If the student wanted to move to Wyoming, that'd be fine. But if you're sitting in Wyoming delivering programs in Maryland, the approval has to be pegged to the state of Maryland standards.
I am concerned about the burden for institutions on this. Do you see any additional in determining whether the high school meets the requirements of the state that the student's actually from?
We're not talking about where the student is from. We're talking about where the student is located.
Where the student's located, rather. Right.
No, because then if that student is not attending a real high school, in the case of somebody who's younger than 18, they're subject to state truancy laws because they're not attending a high school that the state recognizes. Right?
Right.
Now, our population we're concerned about are probably not below 18. But that's a really nice way of thinking about what constitutes an acceptable high school. If it's not good enough for people below the age of 18 who are subject to compulsory secondary education, it should not be good enough for the department.
Okay, so hold on a second. All right, let me pull that back up again. Just bear with me. Okay, applicable. So right now we have state with a. So you want to pull out the state where you want to delete state where the high agency in the state where the high school, and just take that out and the state where and just have it be the state where the student is located, correct?
Yes, sir.
Is that what you want?
Yes.
Any other any other comments on that from anybody? Okay, all right. I think we can agree to that, Farmer.
Thank you. You won't regret it, I hope.
All right. Any other comments?
I see Kelly's hand up. You're up.
Yeah, actually, Emmanuel's going to step in. He wants to add something to this diploma conversation.
Okay, Emmanuel's in for Kelly.
So we've heard from a lot of our members that are smaller that the requirement to basically validate the high school diploma and have to meet multiple and have to basically determine whether or not, based on multiple state requirements, that high school diploma is valid does present a challenge in the ability with the capacity to be able to successfully do that. So I do understand what my colleague Barmack is saying. I understand where he's coming from. I just wanted to share this is what we're hearing from a lot of our members that are they're smaller in size. And so we've been trying to figure out, a way we could work on compromise language and that could maybe resolve the issue, which is why we had introduced, I guess, the compromise to what we had originally proposed today. We're happy that the department came back with us with some revisions with the applicable language. So thank you so much for doing that. We're very happy about that piece. But there still remains this concern that we're hearing from our members regarding the ability to realistically and successfully validate that diploma if there are multiple state agency requirements just across states, and how do you do that realistically? So I would be remiss if I did not share that on behalf of the members that I've been in communication with about the issue.
Thank you.
Thank you, Emmanuel. Jessica.
Thanks. I just wanted to speak briefly in support of the department on both of these points, and just to encourage people to not let the perfect be enemy of the good here. I think on the high school diploma piece, again, this is just if the institution or secretary has a reason to believe that the high school diploma is not valid. So I think it is far from imposing a wide-ranging requirement that would apply to every student. And I think, as the career services, I think that what this prohibits by its language is, or what it requires is adequate career services, and that the specific are points that the secretary can consider and what determines adequate career services. I don't think that the high level point is controversial. I think there's largely agreement here. And I'm not even sure that there's disagreement that the sub bullets are somewhat rational. The department could consider them. I think that the disagreement perhaps goes farther down the line in terms of how people might perceive those requirements to apply. Thanks.
Thank you.
Thanks, Jessica. Okay, any other comments? Yeah, I don't see any. So just a reminder, we're gonna, does it make sense at this point, let's say, to take a consensus check? And if so, let's see, everyone, as a reminder, make sure that you hold your thumbs up high so we can see them, either up, you can live with it, or down. And then just as another reminder, if you do vote down, if you could identify what is a deal breaker, how you change it, and also, is there any specific language that you could propose to try to reach a consensus? So that being said, if you could please hold your thumbs up so we can all see them. I'll go through a roll call just based on who I can see. And if I miss someone, please let me know. Okay, I see Marvin Smith is okay. Jamie, do you have your... Okay, was it Greg's up? Okay, thinking. Sorry about that. Let's see. Anne can live with the consensus. Barmack is up. Adam is up. Ashley's to the side. Debbie is up. Carolyn's up. Ernest is up. Jessica is up. Amanda's up. Katie's to the side. Sam is to the side. Brad is voting against, and Jamie is to the side. So we, based on what I see, we do not have consensus on this issue. So Brad, you have deal breakers, or is there specific language you'd like to propose?
Based on all the feedback, I'm surprised I'm the only one that was a no, but it was three things for me: career services, not defining that, not defining high dropout rates, and no change to the misrepresentation piece of, but those were clearly spelled out in my comments over the last three sessions and been consistent on that every week. So no real change in theory in week 3.
Okay, thank you, Brad. Okay, since we don't have consensus on administrative capability, I'll turn it back over to Greg. Would you like to start with the gainful employment?
Just give me a second to pull that up.
Yeah, and just while you're doing that, just so everyone has a time check, it is 3:16 Eastern. We have 14 minutes before public comment starts.
So before we get into gainful employment, yes, obviously we only have 15 minutes. Remember that tomorrow, I'll just introduce it, maybe do a couple things here. Tomorrow we have the presentation on data from Mr. Fu will be joining us again. Always good to hear from him, and he's got a great amount of expertise on those issues. So like the rest of you, I'll be excited to hear from him. Before we get into gainful employment, I want to remind, this is not so much for the negotiators as it is the public in general. We've received a number of, but we've been receiving a number of comments, many emailed to me or to the negotiation site with respect to a couple of issues. But I just want to reiterate that the department cannot take comments in that way at this time. So currently, if the only mechanism for making comments is through the public comment period, and then Comments will be solicited once we publish a notice of proposed rulemaking, and there'll be at least 30 days for individuals to make comments. The other way to express your opinions would be to let one of the negotiators whose constituency you share know your feelings on that, so that they could convey it. But obviously, when we get the comments, there's really nothing we can do with them when they're simply emailed to us. So I just want to point that out. Okay, that said, we're moving on to issue paper number 3. And even if we don't get very much into this, we'll at least have raised the issue today and be ready to go on it tomorrow. So this is gainful employment, and a couple of changes here we'll be talking about. So I would like to move into hold a second here. I want to see if I'm right. Okay, let's move on to 668 in subpart Q. We'll go to 668.402 in the definitions. And here we are addressing classification of instructional program, or SIP code. And just as a review, taxonomy of instructional program classifications and descriptions developed by the U.S. Department of Education's National Center for Education Statistics. Specific programs offered by institutions are classified using a 6-digit SIP code. However, for the purposes of this subpart, the Secretary uses the first 4 digits of the SIP to identify gainful employment programs. And for simplicity, we have deleted some of the extraneous language here. You can see that we have that are comparable in content and objectives, and just and simplified that language. Staying in 402 and moving over to cohort period, and that is looking at 1 for the 2-year cohort period, and I'll just review that. For the 2-year cohort period, well, actually, before we, the 3rd and 4th years prior to the year for which the most recent data are available from the federal agency with earnings data at the time the DE rates and earnings threshold measures are calculated pursuant to 668.404 and 668.405. For example, given current data production schedules, DE rates and earnings threshold measures are calculated to assess programmatic eligibility in award year 2022, 2023 would be calculated in 2015 and 2016, and earnings data would be measured for the calendar years 2018 and 2019. And then you can see in Romanet 2 for programs whose students are required to complete a medical or dental internship or residency, the 6th and 7th award years prior to the year for which the most recent data are available from the federal agency with earnings data at the time the DE rates and earnings threshold measures are calculated. For example, given the current data production schedule, DE rates and the earnings threshold measure calculated to assess programmatic eligibility in the award year 22-23 would be calculated in 2021. The 2-year cohort period is award years 2011, 2012, and 2012-2013. So just some background here. We've updated the text here to ensure the timing of the metrics and the years in which the cohorts are measured are accurate. Note that the rates will be calculated using earnings data from 3 years out rather than 2 years out, from which the students graduate from the institution. And I will leave it there and open the floor for discussion on that topic, since it's a little bit, there's a little bit of a substance there. So entertain any comments at this time.
Thank you. Trying to get my computer to show me who's next. I'm sorry. Hold on. Ann, you're up.
I was just seeking some clarification. I know when the data came yesterday, along with some of the data definitions, we were advised that there would be a presentation that we would receive on the new earnings threshold and other aspects before we went into the revised language. So is that not going to happen?
Yes, that will happen tomorrow morning. At first thing tomorrow morning.
Okay.
So we will have the presentation on data at that time. I just wanted to get a heads up on this and introduce some of this and see if we have any. But no, I'm not precluding the data presentation, which you will get. You will get the first thing tomorrow morning.
Thank you.
If I will say, let me just throw this out. If people, if it's the consensus, let's not use the word consensus. If it's the opinion of the group that it would be better to wait for that presentation before we have any discussion about this, I'm willing to do that. We're approximately 7 minutes away from public comments. We could take a brief break until that point. Does anybody object to that? Let me put it that way. Okay, then I'll just make a decision. I'll ask. Let me ask the facilitator how they feel about it.
It's fine. I was just, yeah, that's it. We have looks like it's 3:24 Eastern. We have public comment in about 6 minutes. If you want to hold off and start fresh with that presentation in the morning after roll call, seems like a logical point.
Yeah, I think that might be best in view of the comments. So I thank the commenter for sort of insinuating that, and we'll perhaps wait for that presentation tomorrow morning. I think that would be a better segue into our discussion.
Okay, we still have 3 hands up. Are those hands related to that particular issue? Is there something else that would like to be raised? And before I get to any of you, just so you know, Emmanuel is joining us for private nonprofits, and Travis has stepped in for service members and vets. So
I just want to make sure. Can you hear me? Because I switched to my headset. Okay.
Yeah, we can hear you.
I would just pose the question. We only have just a couple minutes, 6 minutes before public comment. Emmanuel, Marvin, you had your hands up. Is there something you'd like to say? Because I'd like to give you that opportunity prior to closing out today. I see Marvin shaking his head, and Emmanuel. It's up to you, Emmanuel, you're up first. But I do want to give them the opportunity if they would like to take the time.
Thanks, Cynthia.
Mm-hmm.
So my comments are substantive to the changes. So I'm happy to wait until tomorrow when we have that substantive conversation, as long as I can still be in the queue. So.
No way, you can't be in the queue. No, yeah, I think absolutely you'll be in the queue. Yeah.
Okay, thanks.
Right.
You'll be listed first. Go ahead.
Right. Okay. And then Marvin, you were indicating, yes, you wanted to speak.
Yeah, I don't know if it's possible for tomorrow's presentation, but I'm really interested in small program rate data and how that's going to be shared with institutions and what we can do with that information, and if there's ever any chance that we can get at more specific small program data, because the department's the only one with that information, and so we're kind of in the dark about what that small program rate means for institutions, and the same for students. I think they'll be in the dark. So I don't know if that's on your radar to talk about, or if NCES could talk about it, but I just throw that out as a suggestion.
We can certainly bring it up tomorrow, and after the data presentation is over, we'll certainly address that.
Thank you.
Okay, we have about 3 minutes, and I see, let's see, Jamie and Amanda, so if you keep your comments brief, it'd be appreciated. And I also see, before we get started, Jamie, that Brad also would like to have his comments be deferred till tomorrow. So Jamie, take it away.
Okay. Real quickly, because maybe somebody wants to be thinking about this. This is a definitional issue, not related to the data presentation. We now have regulations that address medical and dental programs that require residencies or internships following the education portion and relate to the timing of salary information. I have learned that there are other programs that for which a person cannot be licensed until they have completed those residency and other training programs that would like to be included in that provision so that their salary period runs from the time that the person has actually completed the necessary elements for being a full-scale professional in that field. I'll follow up with that tomorrow.
Okay, if you have specifics tomorrow, please bring those to our attention.
Thank you, Jamie and Amanda. Go ahead.
Yeah, I included my request in the chat, but just to have it out loud for the public. The data we received last night had designations and control for HBCUs and tribal colleges and universities, but did not have a designation or control for institutions designated as HSIs. So it'd be helpful to also see the earnings threshold and other impacts of the GE rule on HSIs.
Thank you, Amanda.
Thank you, Amanda. And we have less than 1 minute until public comment. So I guess we can wait for about 30 seconds or so, and then we can.
Kevin, I would suggest we go ahead and start with the public comment.
Okay, sure.
We've got folks in the waiting room, so I can start admitting them.
Go ahead. Who do we have up, Brady?
I'm first admitting Christopher Bartow, who is the Vice President of Government Relations and Community Affairs at LIM College.
Thank you, Brady. Hey, Christopher, can you hear us?
Yes, I can.
Wonderful. You have 3 minutes for your public comment, which will begin when you start speaking. You have the floor. Go ahead.
Okay, thank you. Thank you to the department and negotiators for the opportunity to provide testimony today. My name is Christopher Bartow, Vice President of Government Relations and Community Affairs at LIM College. LIM College is a third-generation family-owned and women-led institution founded in Manhattan in 1939. The college is well known as a pipeline of top talent for the fashion industry and has a long history of successfully educating students and preparing them to become gainfully employed in the business of fashion and its related industries, offering a wide range of innovative bachelor's and master's degree programs. The college has been accredited for over 40 years by the Middle States Commission. For 16 years, the Princeton Review has named LIM to their Best in the Northeast list of colleges. Earlier this year, a Georgetown study focusing on the ROI for low-income students highlighted that LIM College's 40-year net present value of $975,000 is higher than the median MPV for low-income students across all sectors of higher ed. LIM College alumni number over 10,000, over 90% are women, and almost 50% are alumni of color. Most have gone on to build successful careers in middle and senior management at well-known fashion and related companies. Our history of strong career outcomes and earnings provides a perfect example of the inherent flaw of the GE regulations. Looking at recent college scorecard data for our most popular degree program, a bachelor's degree in fashion merchandising, we see that LIM's program has the 5th highest earnings of 51 similar degree programs. Based on the 2014 metric and the scorecard data, this would have a DE rate of 5%, while similar degrees at Eastern Michigan and Immaculata would have rates above 8%, with program debt almost equal to median earnings. That the department's current proposal to lower the failing DE threshold from 12 to 8% would leave students in these underperforming programs unprotected. On every objective measure of gainful employment, LIM's degree programs are succeeding. But when you then factor in the cumulative effect of other changes to the DE calculation currently being proposed, including counting student debt above the previous tuition fees and books and supplies limit, and commingling parent plus loan debt with student loans, this much higher median debt amount that includes borrowing for living expenses will have a disproportionate impact on colleges in higher cost urban or suburban areas and those with significant resident student populations. And we estimate that this piling on of new debt, in spite of LAM's strong earnings and employment outcomes, will have the net effect of causing most, if not all, of our degree programs to fail GE, and that most bachelor's, master's, doctorate, or professional degrees across all proprietary colleges will also fail. This is going too far. What are the department's intentions here if the strongest programs in our sector can't pass what is being proposed? What is progressive about this policy if it could eliminate high quality programs that are serving well the very students
30 seconds.
you are presumably trying to help? The vast majority of college students attend a public or private nonprofit college and intend for their education to lead to jobs. To purposely exclude these institutions indicates that lower outcomes and poorer returns on education investment are unimportant for students in the same type of degree programs at public and private nonprofits.
I'm sorry, Christopher, your time is up.
Thank you very much. Appreciate it.
Thank you. All right, Brady, who do we have next?
All right, I just admitted Steve Patterson, who is here representing the Veterans Education Project.
Welcome, Steve. Can you hear me?
I can, yes.
Great. You have 3 minutes for your public comment, which will begin when you start speaking. You have the floor.
Good afternoon. My name is Steve Patterson. I'm a veteran of the Air Force and served as a military police officer. I'm also the executive director of the Veterans Education Project. Thank you for the opportunity to speak today. We've heard from veterans, policy experts, organizations about how restrictions on veterans education benefits will hurt individual veterans, their families, their future earning potential, and military morale, recruitment, and retention throughout our armed forces. We echo those concerns, as well as calls for more representation from impacted constituencies, like current student veterans. Ever since we participated as negotiators in the last NEG-REG, we've called upon the department to include student veterans themselves in these discussions, and are dismayed that their voices are only heard through public comments and not at the table directly. We'd like to see more representation of student veterans. I'd like to, however, use my few minutes to share our concern about the continued vilification of schools many servicemen and women are proud to attend, as well as call upon the implementation of data-driven policy that is equitable to veteran students at all institutions of higher education. Student veterans choose to go to schools that are committed to serving their unique needs, not because of a school's tax status. While we commend the spirit of accountability, it is frustrating to try and understand how policymakers so easily look past the great number of underperforming public schools, the institutions that veterans overwhelmingly enroll in, and not hold those schools to the same standards as private institutions. This is especially concerning as changing the 90-10 rule will force a significant number of veteran students to be limited to nonprofit and public institutions that have far less federal oversight. We're committed to data-driven policy and the further accessibility of data relevant to student outcomes at all institutions. Part of the problem of focusing so much on 90-10 is that it evaluates non-traditional schools not by student outcomes, but by revenue sources. A more effective policy would be to assess student outcomes directly, which is why we urge the implementation of waiver pathways for schools with good student outcomes, so that veteran students are not collateral damage of the 90-10 rule. A better path forward for veteran students is to make the gainful employment data of all institutions more transparent and easily accessible for prospective veteran students. This transparency would empower veterans to make an informed decision on where to use their earned benefits and to help answer the concern that prospective students are disadvantaged consumers. This kind of change to transparency would remain relevant and beneficial for years, even with changes and innovations within higher education that regulations struggle to keep up with. The best protection for student veterans is to provide good information so they can be empowered to judge the program based on its real world merits. Thanks for the time to speak with all of you today, and we hope to continue this conversation.
Thank you, Steve. All right, Brady, who do we have next?
Okay, I just submitted Ryan Ziegler, who is here on behalf of the Special Operations Association of America.
Thank you, Brady.
It looks like he's logged in, but he's still getting audio, etc. worked out. Do you want me to move on to the next speaker and I can message him?
Sure.
Okay. Next up, we have Dr. Sarah Partridge, who's here on behalf of the Payne Center for Social Justice at the Thurgood Marshall College Fund.
How's it going, guys?
Hello, Ryan.
Yes.
Let's see. Okay, you can hear me. Good. You have 3 minutes for public comment, which will begin when you start speaking. Take it away.
Okay. My name is Ryan Ziegler. I'm a member and board member of the Special Operations Association of America. Thank you for the opportunity to speak before you today. I'm a physician assistant, a former Special Forces Green Beret, and I hold a master's degree obtained using the VA's vocational rehabilitation program, and have utilized both the Montgomery GI Bill and the post 9/11 GI Bill for my undergraduate degrees. There have been concerning discussions regarding the regulation of veterans' earned benefits. Looking at the student outcomes of the affected schools where these veteran students enroll, the data indicate that changes to the 90-10 rule will likely hurt veteran students and their families, as the student outcomes at these private universities and schools are either on par or better than their public school peers. But the 90-10 rule doesn't care about student outcomes, and in our view, that means it doesn't care about student veterans. Waiver pathways must be implemented that take into account a school's student outcomes, or else these changes will only end up restricting where veteran students can use their earned education benefits, eliminating the school of choice and narrowing their options of where they can attain an education with their earned benefits. I want to focus, however, on how the vilification of these private schools hurts veteran students. The word predatory is thrown around without any clear definition. And when we look at the student outcomes of these private schools and universities and compare them with less regulated public institutions, we see not only acceptable institutions, but institutions that are serving veteran students quite well. The continued slander of this entire sector is an attack on veterans' education, not only in the eyes of the department, but most importantly, in the eyes of their potential employers. Veterans deserve to pursue their first choice in education at schools with good student outcomes, and who have made the effort to adapt to the needs of non-traditional students like veteran students. As veterans enroll in all sectors of education, we would want to see data-driven policy that regulates all of higher education. One of the many drawbacks of the 90-10 rule is that it only regulates one sector of higher education. Public and nonprofit institutions are not being held to the same standards and are clearly exempt from some standards altogether. It is time to care about all veterans in the sector of higher education and ensure quality education for veterans in all sectors. Now, there have been discussions that we think are promising. Continuing those discussions would greatly benefit veteran students in all institutions. For example, simply publishing the gainful employment data of all institutions at the programmatic
30 seconds,
level
Brian.
would greatly improve transparency for disadvantaged consumers and would allow veterans to pursue programs based on real merit. I just have a little bit longer. We listen to data when it comes to policy and support greater accessibility of data relevant to student outcomes at all institutions. As already mentioned, one of the problems inherent to the 90-10 rule is that for-profit schools are not evaluated by their student outcomes, but by buckets of money. The ratio of these buckets is supposed to be a proxy for quality when much more nuanced, equitable, and
Ryan,
accurate
I'm sorry,
policies
your
should
time
be
is
able
up.
to be assessed outcomes greatly. These
All right, Brady.
I believe Dr. Partridge is ready to go.
Can you hear me?
Can, thanks.
Okay. You have 3 minutes for public comment, and that will begin when you start speaking. Take it away.
Thank you for the opportunity to address the committee today. My name is Dr. Sarah Partridge, and I'm a research fellow with the Payne Center for Social Justice at the Thurgood Marshall College Fund. We at the Payne Center applaud the proposed rule changes that would go far to protect students and borrowers, including reinstating the gainful employment rule and closing the 90-10 loophole. We would like to add to the discussion around financial aid award letters and cohort default rates. Choosing to attend a post-secondary program will be the biggest financial decision many people make in their entire lives. The student loan crisis today shows that borrowers overwhelmingly struggle to pay back their loans. We believe that the current proposed language around financial aid letters is not nearly specific or detailed enough to fully inform borrowers of the terms of their awards. We recommend that the concerns raised by Amanda Martinez of Unidos be more fully addressed. In addition, we propose the following mandatory disclosures to financial aid letters. First, a standard set of definitions of financial aid terms and the accurate categorization of each type of award or loan. Second, key information such as the total cost of attendance, a breakdown of direct and indirect costs, and the net cost to the student. Finally, directions to access the College Scorecard Data Navigator and the Federal Student Aid Loan Simulator. These important soft accountability mechanisms will only have an impact if students are made aware of them, and the financial aid letter is the most relevant opportunity to do so. Next, there is evidence that the way the cohort default rate is calculated can incentivize forbearance steering. A loan may be put in forbearance for up to 3 one-year periods, a timeline that could potentially push defaults past the 3-year period of oversight. Inappropriate use of forbearances is extremely harmful and expensive for borrowers who will pay more over the life of their loan, forego time on the path to IDR forgiveness, and lose the opportunity to use these pauses in the case of future hardship. Loan servicers offer CDR management plans to schools, which may allow for collaboration, which runs counter to borrowers' interests. A 2018 GAO report showed that it was also a common practice for schools to hire CDR management consultants, and there were instances where these third parties encouraged abusive forbearance patterns. With this in mind, we propose the following changes. First, targeting program reviews for
30
institutions.
seconds, Dr. Partridge.
Program reviews for institutions that have high rates of extended and serial forbearances during the first 3 years, or high rates of default in the 4th or 5th years. Second, requiring schools to disclose their default management plan contracts with loan servicers and third-party consultants. This issue further points to the need for an income-driven repayment waiver, similar to the PSLF waiver, which would help rectify the financial impacts of a system that steers borrowers towards harmful forbearance patterns in multiple ways. Thank you.
Thank you. Thank you for your comment. All right, Brady, who do we have up next?
All right, I just admitted Joan Hannett, who is the founder and president of the Soma Institute.
Hello.
Hello, Joan. Can you hear me?
Yeah, I can hear you.
Great. You have 3 minutes for your public comment, which will begin after you start speaking. You have the floor.
Good afternoon, and thank you for giving me the opportunity to speak today. My name is Joan Hannon, and I'm the founder and president of the Soma Institute, a private vocational school located in downtown Chicago. Soma specializes in alternative healthcare training with a focus on clinical massage therapy. Students graduate from Soma with an average median debt of $7,900 and earn an average of $40 an hour. Our on-time graduation rate is currently 79%. Focused, inclusive, and supportive for-profit education can work. We believe all higher education institutions should be subject to strict performance metrics, and we agree that quality assurance metrics, such as gainful employment, should be applied on a program-by-program basis using their 6-digit CIP code. This will ensure that each training program is evaluated separately and not grouped together with other programs in related but distinct fields. The current proposed gainful employment metrics of debt to earnings and discretionary income are arbitrarily low and unnecessarily complex. As we understand it, the aim of gainful employment regulations is twofold. One, to ensure that students are not saddled with heavy debt repayment obligations relative to their earning potential, and two, to ensure that Title IV funds are not being wasted on certificate programs that do not lead to gainful employment. Perhaps a better way to achieve these goals would be to establish caps on the total amount of debt financing that a school can provide to a student based on their program of training. Reasonable gainful employment metrics, such as the debt to earnings ratio, could be used to set the cap. We also believe that adding a second metric of an earnings threshold, such as the average earnings of a high school graduate, is not appropriate. The use of such a metric would eliminate vocational program choices available to students and limit their career options. The biggest problem with the proposed gainful employment regulations is that they are selectively applied and targeted at for-profit institutions. All higher education institutions, regardless of their profit or not-for-profit status, should be able to justify the investment of time and resources that our students invest in their education. Let's make the gainful employment rules simple, fair, and equally applied. Thank you so much for your time today.
Thank you.
Hey, Brady, before I go to you real quick, if there are public commenters that are registered, they need to log in now. And they need to log in under the name they've registered under. That being said, Brady, who do we have?
I just submitted Michael Cole, who's here on behalf of the Tulsa Welding School.
Welcome, Michael. Can you hear me?
I can. Can you hear me?
Yes. You have 3 minutes for your public comment, which will begin when you start speaking. You have the floor.
All right. Thank you, guys. As noted, my name is Michael Cole. I'm the campus president at Tulsa Welding School in Jacksonville, Florida. But today I wanted to speak to you as a former student of a proprietary for-profit school. Out of high school, I went away to the traditional route and found myself in a situation where I had to return home due to life circumstances and wasn't sure what I was going to do. Had some of the rules like we're proposing here go through, I wouldn't have had much choice. I chose to go to a school in Pittsburgh, Pennsylvania called Western School of Health and Business Careers, and in doing so, I was able to get my diploma, actually my associate's degree in pharmacy technician, and I was able to find a job that helped me provide for my family and allowed me to parlay that into another private school and get my bachelor's degree and master's degree. Had it not for the choice that I had option, I wouldn't be able to sit here in front of you and have the living and the opportunity that I've had for my family. I ask that when you're looking at rules, please be fair and consider what could happen to students in my situation that don't have the circumstances all the time to go to a traditional school or go to a traditional route, or when life happens and changes, it makes them have to change a different course. I have the opportunity right now to work in the skilled trades, and I know that we're in a situation where we need a ton of skilled workers, and I'm proud to say that Tulsa Welding School contributes more welders than anybody else in the country to that growing demand. Please, again, when you're considering these rules, take that into consideration. We need welders just as much as we need doctors and lawyers. We have to have people that can build the things that everybody wants to use for the traditional schools. I ask again one more time, please just be fair when you're making the rules that come for us and impact all of us, and don't just look at it from one side. Thank you.
Thank you for your comment, Michael. All right, Brady, who do we have next to comment?
I am admitting Dr. Aaron Banis, who's here representing themselves.
Dr. Banis, can you hear me?
Yes, I can hear you.
Okay, you have 3 minutes for your public comment, which will begin when you start speaking. You have the floor.
Okay, thank you. So again, my name is Dr. Aaron Banis. I am a active duty lieutenant in the United States Navy, where I serve as a clinical psychologist. I'm joining this call just to share briefly my experience with University of Phoenix. So I'm prior enlisted. I in high school I did okay. I tried community colleges kind of here and there. It didn't really fit for me. So I joined the Navy in 2003. Towards the end of my enlistment, one of my peers, who was also going to University of Phoenix, connected me to the program, and I jumped into it, and it really felt like a great fit and connection. I learned a lot about how to write. The writing assignments were on point. It really helped me with my job in the Navy as a psychiatric technician, and really helped me get meaningful jobs after my time in the Navy. Once I graduated from University of Phoenix in 2010, I continued in just outside of the military, in military settings. But then I was accepted into the George Washington University professional psychology program, where the skills that I learned at Phoenix really helped me to evolve and grow. And I felt I was successful. I went to a pretty rigorous program, and I felt that the things I learned there were very meaningful. And so I guess the reason why I'm speaking here is in the hopes that people like me in the future also have the same opportunity to do what I did. They were kind of unsure what to do at first. Maybe they struggled with school a little bit, but to have a place where that's supportive for their academic goals, it kind of meets them where they're at and helps them to achieve greater things, and can help them, as Phoenix did with me, achieve career goals, get them on the path they love to do. And so that's all I have. Thank you very much for your time and for listening, and for listening to me today.
Thank you, Dr. Bass, for your comments. Appreciate it. Ray, do we have anyone else in the waiting room?
No one else is in the waiting room right now.
Okay, I would suggest, Kevin, I mean, there are 2 registered speakers, one with a slot of 3:54 p.m. and one at 3:57. We do need to wait, in all fairness, to see if they do log on.
Sure.
You could go over any housekeeping items for tomorrow in the meantime, so that if they do log in, we can let the committee go as soon as they completed.
Sure. And correct me if there's anything that I'm missing, but from what I understand, the next session tomorrow, we'll pick back up with gainful employment. I believe when we last, before public comment, we talked about a presentation towards the beginning of the session after roll call. That'll begin at 10 a.m. We'll go through starting with gainful employment, and our break at lunch tomorrow will be at 12 noon. Greg, is there anything else from the department regarding, previewing tomorrow's session?
No, we hope to get through. Gainful employment, and if I'm being optimistic, so I'll start financial responsibility tomorrow. But that's our plan. But yes, you're correct. We'll have the presentation tomorrow morning, and then questions related to that, and then we'll go into the issue paper text.
I do want to add that I do want to remind the committee that, given the fact that if you are in dissent of any issue paper, that you do come prepared with, language that would you could present to the department for their consideration, so that we can see if we can get to consensus on a, rather than breaking off on the issue with no consensus. So other than that, I think we are at 3:54. We have about 3 minutes. Does anyone have any questions about what's going to be on the agenda tomorrow? Brad.
I just want to make a suggestion that we take off smaller components. I mean, I know we went all the way through 2.5 pages in the initial kind of flip that Greg did, and I'd like to take it more in a systematic way so we're not jumping all over the place if possible.
Thank you. I think that would be the intent, and thanks for bringing that up. Today he was just more or less trying to give just a, get as far as he could into it for an overview, recognizing that you have been told that the presentation would be held before the discussion, and that was always the intent. So we do appreciate that. Johnson?
Yeah, I understand Professor Looney is going to be talking. If there was someone at the Department of Education who helped prepare the data who could also answer questions, or I don't know if Dr. Looney did the whole thing himself. I just have some very specific questions that I would hope would be answered. Thanks.
Thank you. Okay, so our registered guest for 3:57 has now logged in. So Brady, you want to go ahead and admit them?
Absolutely. I just admitted Allison Johnson, who's a veteran representing themselves. It looks like they need to enable audio and they'll be all set. There we go. They should be able to hear us.
Great. Allison, can you hear me?
I can hear you.
Great. Welcome. You have 3 minutes for your public comment, which will begin when you start speaking. You have the floor.
Thank you. Good afternoon. My name is Allison Johnson. I'm a veteran of the U.S. Army. I am here today because I want you to know how for-profit colleges like Kaiser University takes advantage of disabled veterans. Shortly after leaving the military, I enrolled at Kaiser to further my education and to transition to the civilian life. Though I am grateful for the opportunity to serve my country and have many great memories of my time in the Army, serving in the military also involved difficult experiences that left lasting impacts on my mental health. This January, my doctor recommended that I take time off from Kaiser so I could get mental health treatment I needed. Everything started out fine. I requested medical leave of absence and provided the document from my healthcare provider to the school I requested. The associate dean notified me in writing that my request was approved and that I would not be charged for the courses that term. But a couple weeks later, my online account showed that I still registered for classes. I contacted the associate dean again, and she said not to worry. She confirmed that I'd been withdrawn from my classes, placed on medical leave, and would not be charged. It seems odd that my account still showed I was enrolled, but I thought I could trust the dean. But then a month later, my academic advisor asked why I had not logged into my classes that term. I forwarded the email showing I was approved for leave of absence, but no one paid any attention. Soon the financial aid office was telling me that in addition to using my Pell Grant, I would need to tell the VA that I took classes that term so they'd give me my benefits, or else I would have to pay $5,000 out of pocket to the school. I was shocked and upset. I would never ask the VA to pay for classes that I did not take, so I am continuing to urge Kaiser to remove the charges for my classes they assured me that were taken off of my schedule. Instead of being able to use my medical leave of absence to work on my mental health, I spent weeks dealing with the issue. It's been so stressful that my mental health is actually worse than before. Kaiser preys on disabled veterans like me because they think they can get away with it. The Department of Education must prove them wrong. Please prioritize the well-being of disabled veterans for over-profit executives who are trying to just make a buck. If the Department of Education doesn't do more to regulate for-profit schools, disabled veterans will continue to pay the price. Thank you.
Thank you, Allison. Thank you for your comment and for your service.
Thank you.
Okay. That's it for public comment for the day. The session for today is completed. The next session will begin tomorrow at 10 a.m. We can stop the live feed, and everyone have a good evening and stay safe.